Almost 4 years of tenure at the Supreme Court, a fantastic tenure at the Allahabad High Court as well. I have with me Justice Krishna Murari, who recently retired from the topmost court of the country. So, welcome to CNN News 18. So, first questions, very interesting one. What are the plans post retirement?
See, I have almost put in 43 years in this profession. Now, of course, I will not be retiring, but I am not interested in taking any heavy assignment. But yes, whatever I have learned from my experience, I will definitely like to give back to the society, serve the society. So, if arbitration is one field where if I get some work, I will definitely do. Otherwise, I will spend time reading, doing some social work, moving around, seeing the world. These are the plans for the future.
So, you've spent almost 4 years at the Supreme Court. You've seen, since 2019, you've seen 3 law ministers coming in, Mr. Meghwal, Mr. Kiran Rijiju, and in fact Ravi Shankar Prasad as well. What was the difference between the 3 tenures? We've seen how during Mr. Rijuju's tenure there were certain controversies as well as to how the Collegium system was being constantly challenged. Now things have changed in Arjun Ram Meghwal's tenure. How was the experience in the 3 tenures?
See, we do not have much concern or much to do with these political statements. They are all political statements. But then, yes, it was slightly different at the time when Ravi Shankar Prasad ji was the law minister. Kiran Rijiju was also good. Insofar as the present law minister is concerned, I have never had any opportunity to meet him and I don't even know him. But all the chief ministers, all the law ministers, they are all these statements and everything, to my mind, are politically motivated. That does not seems to be. Otherwise, the collegium system is working well. Recently, whatever recommendations have been made, they have been cleared by the government. So, I have nothing much to say on that, because that is neither here nor there, nor I feel myself competent to comment upon that.
So, there are a lot of times, and in fact, Justice Chanchur also spoke about this issue at various exposure where he has spoken, that judges are often criticized for the judgments that they pass. I remember recently when the Nupur Sharma case happened, Justice Pardiwala and Justice Suryakant were also, in fact, criticized for their statements in the matter. How do you see this criticism, especially in times of social media, and if at all you faced some kind of this, and how do you deal with this? Does it affect the judgments?
This criticism which moves around on the social media usually does not affect us. Anybody who reaches the Supreme Court has 15, 20 years, 18 years of experience behind him working as a judge. Of course, in this country we have, everybody has a freedom of speech and expression. So, they express their views the way they see the things, but it does not affect the judges at all. We are not swayed or swayed by these comments which are made, because sitting there hearing a matter, when you pass a judgment, the judgment only goes before the person or the public, and most of them are not well aware with the intricacies of law. So, they see it in their own way, and they, whatever they feel like, they speak about it.
Very recently, just this week itself, the Supreme Court passed a judgment and said that the ED director's tenure should be reduced because in the 2021 judgment, the Supreme Court had said that Mr. Sanjay Kumar Mishra should not be given an extension on this. And in fact, the Supreme Court had also held recently in the 5 judges constitution bench in the Vijay Madanlal Chaudhary case the powers of the Enforcement Directorate. But there are a lot of questions raised, like the CBI and ED are being misused by the government. These are the political arms of the government being used against the opposition leader. How do you see this?
See, insofar as the judgment is concerned, I have not read it, but the presumption is that when the Supreme Court delivers a judgment, It is well considered. It takes the law into account, the facts into consideration, but without reading the judgment, I don't think that I am able to pass any comment on that. And secondly, misuse of ED or misuse of other investigating agencies for political purpose is concerned, there are a lot of hue and cry. But one who is actually affected by it, the courts of law are there. He can approach the court of law and raise his grievance over there. Merely by shouting that ED is being used for political purposes, everywhere, every day, newspaper, social media, this is there. But I think the affected person should approach the court for addressal of the grievances. Passing a general comment by a judge or one who has been a judge will not be very appropriate unless we know the facts, we know the truth. We only see what is said on the social media or what is published in the newspapers. So, that is only one side of the story.
We've seen the Collegium system working for a long time. The Collegium is the law of the land at this point of time, but there were questions raised that there should have been NJAC be brought back, or there should be a better system of appointments. And it's not only the political parties, but also many from the legal fraternity think about it. Do you think that the Collegium system needs a rework, since you've been in and around law for ages now?
Yes, Collegium system needs a little revamping, but unless we are able to find and substitute the present system with a better system, this system is working. Even I am a beneficiary of that Collegium system. Secondly, I have been a part of this system till very recently. If anything was required to be done, I am not saying that whatever was required to be done was done or not. But then once one goes out of the system, I don't think he has a right to criticize that system of which he has been a part. If some improvements are to be made, then it is his duty, one who has been a part of the system, it becomes his duty to raise his voice while he is within the system. It's always easy to criticize anything once you are out of the system. Nobody raises a voice while being with the system and in the system. And once you are out of the system, you start raising all sorts of objections. If I had anything to say about the Collegium, I could have discussed it when I was a part of the system. But yes, this much cannot be denied, that government is an equal stakeholder. But unless all those who are dealing with this, they find a better system to substitute this is doing good. And sometimes the fault is not with the system, the fault is with the people who are managing the system. So, you can't criticize the system as a whole or discard it as a whole, because people who are managing are not able to do what is required to be done under the system.
Another question that stems from the same issue is that, there was a Collegium resolution, if you remember, with regards to Mr. Saurav Kirpal that was passed, where reports of the Intelligence Bureau and RAW were discussed, the finding of those reports. Many criticized it, many said that, sharing of the IB reports and the RAW reports in public domain is something that is not right. How do you see this? You've been part of this.
See, sharing of the IB reports or sharing of any of the reports which is sent to the Collegium strictly in confidence, in my opinion, should not be made public, for the simple reason that if the reports in that regard with respect to a particular person comes in public domain, then his reputation, his career is is always at stake, and most of the time it is destroyed. And the poor man does not even gets an opportunity to defend himself. IB reports or investigative reports which are given in these matters are not like investigation under the Criminal Procedure Code, where the party is involved and he is given an opportunity. It's just for the Collegium and the government to take a decision whether to act upon the IB report, what is truth in it, and moreover one can only make a comment when one sees the actual report. I never had any opportunity to go through the report. Whatever I know is from the newspaper reports or the social media. So, I do not find myself competent to pass any comment on that in respect of something which I have not myself seen or read.
Uniform Civil Code is something that is going on. It's a debate that's all across the country at this point of time. The Law Commission is already seized of the matter. It has invited public opinions. Since you've been a framer of law, you've studied law, preached law for a long time, do you think that in a country as diverse as ours, there can be such a code that brings uniformity, or would it be beneficial, and can it be brought as well?
See, uniformity will always be beneficial, but before this Uniform Civil Code is implemented, there should be a large scale consultation with the public at large, and just enforcing it like that may not be good for the country, for the society, or for the public at large. But once there is a general discussion with the public at large and majority view comes forward, then only it should be, and whatever is the proposed code, that should also be brought in public domain, so that everybody has opportunity to look into it, raise their concerns and objections, and the government should only implement it after large scale consultation.
So you've the last 2-3 years since Justice Chanchud has actually taken over, and even before that he was a part of the E committee of the Supreme Court. We've seen a lot of changes coming in at the Supreme Court. On the technical side of it, we are seeing how artificial intelligence is being used, how neutral citations are becoming a part of it. How important do you think that artificial intelligence could be in terms of judiciary, and what is the future ahead, according to you?
See, use of this technology, we have seen that if the use of this technology was not there, then probably all the judicial system or entire courts of the country would have been shut down. Even we at the Supreme Court, during the peak corona period, maybe the Supreme Court was not functioning to its full strength, but at least important matters means important for general public, like personal liberty matter, bail, etc. At least maybe even all the judges were not, since the system was being implemented, this facility might not have been available to all the judges, to the entire Supreme Court, but then something was being done for the litigants. If this system was not there, then it would have been a total shutdown. So, it is in a way very good, and otherwise also the video conferencing facility. A litigant, supposing he is not in a position to come down to Delhi to engage a counsel, he has already a counsel at the High Court level or at the local level. Video conferencing provides him the facility that his counsel can argue the matter from where he is. And artificial intelligence, of course, is going to help a long way, because in one of the constitution benches, on a trial basis, a system was installed. I was a part of that constitution bench, where every argument or anything which was uttered without shutting out the mic, that was recorded and it came on the screen along with the name of the person who was speaking that. So, if all that is recorded, it comes and it can be downloaded, at least for the judges it would go a long way in finalizing the judgment, because then there would be no possibility of missing out anything which has been argued or cited. These are days when the technology is ruling the roast. Why judiciary should be left out of it? And I see that this use of technology in the dispensation of justice is for good, not for any detriment.
You were a part of two important constitution benches.
Yes.
First, I'll go for the Maharashtra case you were a part of that bench which ruled that, though in fact there were some discrepancies when it comes to the Sena versus Sena battle, but in fact since Mr. Uddhav Thackeray resigned from his post, that nothing more could be done. But at the same time, we are seeing a change. We are seeing how the NCP is now also broken away from the major faction of the Sharad Pawar. Do you think that it is some kind of a violation of the judgment that was passed, or the anti-defection law that is there?
See, what political decisions have been taken after the judgment, that it has got nothing to do with the judgment. The judgment was only confined to the questions which were raised, whether the so-called defection which took place, whether the governor was, first of all, whether the defection which took place would be hit by the Schedule 10 or not. Secondly, whether the governor was right in calling for a trust vote. But then everything went on the fact that since the then Chief Minister did not face the trust vote and he chose to resign, so there was no alternative available to the court. Once he had resigned, that was the end of the matter.
Another question that stems from it, and we recently have a petition with regards to that. One direction was given by a bench when the matter had concluded, was that the speaker should decide the disqualification proceedings against those 16 delinquent lawmakers. But nothing has been done, is what is being alleged by the Uddhav Thackeray, in fact the speaker. So do you think that this is also a violation? Because if I fondly remember, there was no particular timeline that was given.
There was no timeline fixed. You are right. But you technically can't call it to be a violation, because see, one constitutional authority should not normally encroach upon the powers of another constitutional authority. But it is also equally correct that the two constitutional authorities must have respect for each other. So, out of that respect, the bench thought it fit not to fix a time limit, and the other authority ought to have taken up the matter and decided it, but we don't know what is going on there. At least I am not aware of what has happened thereafter, because the disqualification prescribes a procedure which is to be followed, where a notice is to be given, the concerns are to be heard. I am not aware whether speaker has proceeded any further in the matter or not. So therefore, but then technically it cannot be said to be a violation of the directions.
You were also a part of the Constitution bench that gave out the verdict in the favor of the Delhi government with regards to services. But just after the judgment came in, a few days, in fact on May 19th, the centre brought in an ordinance saying that creating a National Capital Civil Services Authority. So is it something that is a matter of challenge, or it could not have happened? Or?
See, that ordinance is under challenge and sub judice. We are under an obligation not to speak anything about a matter which is sub judice. The bench where the matter would come up, they would test it according to law and then pass a judgment, whether it could have been done, could not have been done, rightly done, wrongly done. But sitting outside, it may be very easy for a member of the general public to say that, but since I have been in the judiciary, I know that it is improper to make a comment with respect to a matter which is sub judice.
Sometimes we see that various Collegium resolutions, if you remember, with regards to Miss Victoria Gauri also came up before the Supreme Court. The Supreme Court heard it. That there is a lot of buzz, sometimes it's said that judges have political inclinations, they pass certain judgments for, a post-retirement benefit or something like these allegations come up. How much of it do you think it is true, or how much of it is correct to actually take up a post-retirement post? What are your views on this whole issue? That
see, first of all, that judges get swayed by these post-retirement benefits and all that is not at all correct. When you sit there and there is a matter before you, you decide it according to law, facts and your conscience. While hearing a matter, it never comes in our mind that, oh, if we decide this matter, we will get that post-retirement assignment and this post-retirement. That is not there. It is all humbug which is created on the social media, having no truth behind it. And insofar as post-retirement assignment is concerned, it is something, a decision to be taken by the person concerned, because there are certain tribunals where the statute provides that they are to be headed by a Chief Justice or a retired Supreme Court judge. So, if the statute has made that provision, and if somebody is interested, he accepts that assignment, what is wrong? How do you connect it with that his judicial discharge, discharge of judicial functions? It's there in the mind of the people. There is absolutely no truth behind it.
A matter recently came up before the Supreme Court with regards to Teesta Seetalwad, 2 subsequent hearings taking place in fact, and the Supreme Court in a very late night hearing on a Saturday passed interim protection for Teesta Seetalwad in this case. Now what the Solicitor General was constantly arguing before the court was that, you know, she is just an ordinary criminal, she should not have been given this kind of a liberty to, you know, approach the bench at such a late time, and a bench should be constituted. And he said that, you know, an ordinary person could not be allowed that. Do you agree?
There he is absolutely wrong. Even if an ordinary person is able to approach the Supreme Court in such circumstances, the Supreme Court would definitely take up the matter like that. It's only the question of approaching and coming to the Supreme Court and letting the Supreme Court know that this is the problem. Teesta Seetalwad is a name. Even without her efforts, for obvious reasons, a lot of people would jump in. How can a Supreme Court come to know of what has happened to somebody, like supposing something like this has happened to somebody at Kerala, at Chennai or faraway places? How the Supreme Court sitting here, there is a procedure prescribed, you have to approach the Supreme Court. So, if that poor man is unable to approach, the fault is not with the Supreme Court. The fault is with the system, where there should be a provision that if anything of the type happens, now the Supreme Court and all others are in a large way, legal aid is being taken up. Time will come when nobody would be able to point out that because it was Teesta Seetalwad, therefore it was taken up. These are all confusions created by saying all this. If the Teesta Seetalwad case would not have reached Supreme Court, did the Supreme Court took it up suo moto? The petition came, so let any XYZ who is that file a petition. If the Supreme Court does not takes it up, then of course people can blame the Supreme Court that it took up matter of Teesta Seetalwad but not of a commoner.
The Law Commission recently came out with a report where it upheld that the sedition law, which is a colonial law. In fact, the government had also in 2021 said that, you know, it's reviewing the sedition law, but the Law Commission said that it's a requirement at this point of time. It's a very, very necessity at this point of time, and though with certain safeguard, it should have been there. You've been at the Supreme Court when the Supreme Court had put this matter into abeyance. You were a part. You were a judge at the Supreme Court at that point of time. What are your comments about that?
See, these questions are such that there can't be a straight and simple yes or no answer to it. These are matters which require deliberations, not only by the experts of the field, not only by the elected representatives who represent the will of the people of this country in Lok Sabha and Rajya Sabha, and of course by involving the general public and the legal experts as well. It's not, these questions are not so simple to answer, yes, sedition law should go away, should not go away. After much deliberations and looking and considering every aspect of the matter, then only the final product can come. But the Law Commission has given its report. That is not final authority. The final authority is the when the legislation comes in and is approved by the legislators, by the Lok Sabha and Rajya Sabha, and becomes a law. There can't be such a simple, the way you have put the question, nobody can answer it, yes it is right or yes it is wrong. Nothing is right or wrong. It requires consideration, deliberation, and then to come to a conclusion.
So, sir, since it has been almost 4 years at the Supreme Court, something that you'll be missing now from the daily life that you have?
See, I've been associated with this great institution as a judge for almost 19.5 years, and if you add the period which I spent at the bar, about 22 years, so it's more than 4 decades. So I cannot say that I'll not miss the corridors of this great institution. But every beginning has its end. When I joined the profession on 22nd of December 1981, I never knew that I would become a judge. But then God has been great and kind. He found me fit to delegate His power. Doing justice is actually godly function. And He found me to be competent to delegate His power to perform His function. That happened on 7 January 2004. I was elevated. That very day, the date of retirement was fixed. It only got extended. It only gets extended by 3 years if you are successful in being elevated to the Supreme Court. So any beginning there has to be an end to every beginning. My period has also come to an end, but then, as I said earlier, I have gained experience by working in different fields of law, and I would like to give back to the society whatever little experience I have by doing my own little bit.
Of this long career, not only at the bench but also at the bar, any significant memory that you are?
See, there are a lot of significant memories, and as a matter of fact, every day when you sit in the court, it's a learning experience. Every day is a learning experience. Nobody can claim that yes, now he knows everything. Sometimes you are all set that this matter has no merits, and right when you are about to close the proceedings, the counsel appearing comes up with an argument, and at times it is so appealing that the entire fate of the case takes a somersault. This has been a great learning experience, and particularly here in the Supreme Court, the bar, the standard of the bar is good. We really have to burn our midnight oil every day to be able to match them next day.
So, we've seen how when proceedings take place, I've been covering the Supreme Court for a long while now. There are certain times when the bench puts forward some questions to being the devil's advocate to a lawyer with regards to a case, but that is misread by the general public at large. So
See, we put questions to explore and to find out what is ultimately it is the truth which should come before us, then only we can deliver, we can dispense justice. So in order to find out that truth, sometimes some questions are put to the learned members of the bar, but the difficulty is that in what perspective that question has been asked is never there. Only the question flashes in the social media. So if you flash anything out of without any reference and context, so it can be misread or misunderstood by anybody. Even if it comes before me, who is a judge, this question was put without there being any reference and context, in what context in reference of what this question was asked, I may also think that what is this question which has been asked. So, it has the things have to be seen in complete totality. Forming an opinion just on the basis of a piecemeal thing, taking it out of context is, but unfortunately social media is thriving on that.
The Constitution Bench of the Supreme Court will on August 2nd begin hearing petitions with regards to the constitutional validity of Article 370 of the Constitution, the abrogation of that article. Things have changed since 2019. There were two union territories being created. A lot has changed on the ground. In fact, the central government too filed an affidavit saying this. Do you think that it would remain to be only an academic exercise testing the constitutional validity of it, or would it be a broader aspect when the Constitution Bench actually hears this?
See, the basic thing would be the constitutional validity, but because the courts are supposed to test the validity of a statute amendment or constitutional amendment on the anvil of the constitutional principles. But the courts also cannot shut its eyes to the practical aspects. So, both the things have to be balanced to come to a right conclusion. The matter is sub judice, so obviously I would not like to say anything about it.
So, last and final question. Recently, a Collegium recommendation was given out, and it was for Justice Gaurang Khan, Justice Siddharth Misdul to be transferred to Manipur and one another state. Justice Gaurang Khan was being transferred. The DHCBA, the Delhi High Court Bar Association, has said that we'll abstain from work. We are opposing this transfer that is happening, and this is not correct. So, such a challenge to a Collegium resolution, because of course you've seen the system. The Collegium takes in all of the aspects into consideration, and in fact transfers are basically administrative exercise being carried out with the Supreme Court. How do you see what is happening?
See, this should be seriously thought by the bar. Raising a protest against something which you don't like, I mean, they may have their own reasons for it, but protest is all right, but what purpose would be served by going on strike? And that is a fact, as you yourself put in the question. Then when the Collegium takes such type of decision, it takes into account so many factors which are relevant for that. These are not, the High Court judges are constitutional authorities. They are not transferred like civil servants are transferred, that you have completed a tenure of this year, now you have to go in some other district. Right or wrong, I am not commenting. But yes, the Collegium definitely takes into account seriously all the aspects before making any such recommendation. The bar may have its own viewpoint. Sometimes you see the things from where you are standing. I will give you an example. If you see a Maruti car standing in front of it, you will find your perception would be it is this big. Now you change your position and go to the 5th floor. From the 5th floor, you will find that it's very small. And if you see it from the 50th floor, it will look like a toy car. The size of the car has not changed. You have changed your position. So, bar looks at the things from where they are standing. The Collegium look at those things from where they are. So, it's a question of perception.
You've seen a lot of Chief Justices in your tenure at the Supreme Court, almost 3 to 4. A fond memory of each of them, or something that you remember of all of them?
All of them have been so good. Unfortunately, Justice Bobde's period there was corona. But Justice Gogoi, the first Chief Justice, he was the Chief Justice, when I came to the Supreme Court, a very witty person, very strong-headed. Justice Boble was soft, very well-read, very knowledgeable. Then Justice Ramanna, of course, he took the office of the Chief Justice to a very great heights. Then Justice Lalit came. He, although he had a short tenure, but he did try his best to improve the system. And it was because of him that all these constitution benches were opened. And he saw to it that the entire, all the judges are involved, or so he constituted the benches in such a manner that everybody was there in one or the other constitution benches. Of course, Justice Chanchud, I have had the good opportunity to see him working as Chief Justice twice. He was my Chief Justice at Allahabad High Court, and again here as Chief Justice of India in the Supreme Court. He has a good tenure, and definitely he has brought in changes which are good for the system, good for the judiciary. Every Chief Justice has his own ideas, and he tries to implement them for the betterment of the system, judicial system as a whole.
Thank you so much. This was Justice Krishna Murari speaking to us on various legal issues and how his tenure has been at the topmost court of the country, and in fact the Allahabad High Court as well. I am Anil Bhatnagar with video journalist Umesh Kumar and Chintan Puri for CNN News 18.
Thank you.
Thank you so much, sir.
Thank you.